Intentionally or knowingly possess a short barrel firearm, to wit, an Eastern Arms 16-gauge shotgun, against the peace and dignity of the state, signed, foreman of the grand jury.
Thank you, Mr. Hartwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty.
Can you please describe what he is wearing and where he is seated?
He's seated at the table there, and he's wearing a light blue shirt.
And you mentioned earlier that you got a search warrant put together. Were you able to execute that search warrant?
Yes, we were.
And what kind of property were y'all actually looking for?
We were looking for gold, coins, and other precious metals, firearms, and items that were specifically taken from that specific residence.
Intentionally or knowingly possess
We are now on record cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. And as I told you, yes, Mr. Young, if you'll please rise. Mr. Hartwell, if you will present the indictment to Mr. Young.
in the name and by the authority of the state of Texas. The grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term that Reginald Hoyt Young II, hereinafter styled defendant, on or about November 25th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally or knowingly possess a short barrel firearm, to wit, an Eastern Arms 16-gauge shotgun, against the peace and dignity of the state, signed, foreman of the grand jury.
Thank you, Mr. Hartwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty.
To be really kind of blunt about this case, it's fairly straightforward. On November 25th, you'll hear evidence that deputies with Smith County Sheriff's Office was investigating another incident that happened in Smith County. You'll hear that Mr. Young was not the subject of that investigation. In fact, the subject of that investigation was a man by the name of Russell Melton. However, during the course of their investigation, the deputies with Smith County were led to the property that Mr. Young resided on. You'll hear that they found some evidence from that Smith County incident on the property. And as follow-up, they got a search warrant and searched the property, where they found a sawed-off shotgun. Good afternoon, Investigator McDonald. Can you please start by introducing yourself to the jury and spell your last name for the court reporter?
Absolutely. Tim McDonald, TIMMCDONALD.
Can you tell me what the basics of that investigation was?
Yes, we were investigating a burglary that took place in Smith County.
What was found as a result of the search warrant?
We located a firearm that was found to be a violation of Texas law.
Mr. Stevens, your witness.
Thank you, Your Honor. Investigator McDonald, I'm Bill Stevens, going to ask some questions. If I don't make myself clear, just please stop me, okay?
Yes, sir. Thank
All
you.
right. Now, how did you derive at the fact that Mr. Young lived at that travel trailer? Other than his statement, was there any evidence that you found that tied him to that travel trailer?
Yes,
What was that?
his vehicle parked.
His vehicle?
His vehicle was parked in the vicinity.
Okay. So because his vehicle's parked there, that means he lives there? Your investigation, he was not the target of your investigation, correct?
That's correct.
Okay.
He was not.
And to your knowledge, was he arrested for anything other than the sawed-off shotgun?
Not that I'm aware of.
Okay. What was the investigation all about that led you out to that location?
It was a burglary of a habitation that occurred in Smith County.
And what kind of property were y'all actually looking for?
We were looking for gold, coins and other precious metals, firearms, and items that were specifically taken from that specific residence in Smith County.
All right, sir, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay. And upon arrival there at that location, who did you meet with?
Met with Deputy Kevin Londoff and Deputy Tim McDonald with the Smith County Sheriff's Office.
And did they advise you of the purpose of their call and why they were at that location?
They did.
And as a result of that, what happened?
So they were there, like I said, investigating a property crime, which was a burglary. They had had a significant number of gold coins stolen out of a safe in the northwest portion of their county. And
Just to take a quick look and make sure that this item is safe. Ask you to identify it, please.
okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
Okay.
The barrel was sawed off with most likely a hacksaw or something to that effect. It's what it appears. It doesn't. It's not clean. It does not appear to have been professionally modified.
In measurements, what are we talking and what would you be looking at?
The barrel should be at least 18 inches long, and the overall length should be 27 inches long, minimum.
No objection, Judge. No objection.
All right, there being no objection, State's Exhibit 6 is admitted.
What qualifies as a prohibited weapon? What was that number in terms
Anything
of
under
barrel
18.
length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 16th over 11 inches.
Now, my client was not charged with anything related from the burglary. Is that correct?
That's my understanding.
Okay. Lieutenant, did you take any fingerprints from the shotgun?
I did not,
You did not. Do you know if anybody took any fingerprints?
not to my knowledge.
Did you ever see Mr. Young possess? I mean, with your eyes, did you ever see Mr. Young possess the shotgun?
No, I did not see it in his hands or on his persons. No, I did not.
Okay. So is that sawed-off shotgun operable?
So I would not consider it operable at this time. No.
Counsel also asked you about whether that sawed-off shotgun is operable. What would it take for it to be operable?
Simply sliding a firing pin into position and loading it.
How long would that take to slide that firing pin?
Just a few seconds.
Right. Third, you swear that the testimony you give before today, will be the truth, the whole truth, and nothing but the truth, so.
Yes.
See. Martinez. During your testimony, support that you speak up loudly and clearly, you have to lean to the microphone. During your testimony, if the attorneys object, Justin Donovan, the court will move on now. Allow the attorneys to completely finish their question before you give an answer, so we're not talking at the same time. For purposes of a clear record. Finally, you're in the emergency vehicle with a mouth shut. Sometimes it makes it difficult for you're testifying, let that sound pass. The attorneys may stop your questioning here.
Okay. Thank you, Your Honor. Good afternoon, Agent Petrie. Can you please introduce yourself to the jury by stating your full name and spelling your last name for the court reporter?
My name is Joshua Petrie, Petree.
And can you tell me what you do for a living?
I'm a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
What does somebody have to do to become a special agent with the Bureau of ATF?
Well, we investigate federal crimes. So typically, like I have a bachelor's degree. I was a police officer prior to. And so there's different paths, but typically you're prior law enforcement before you become a federal agent.
So starting kind of with your education, what do you have a bachelor's degree in?
So I have a associate's degree in criminal justice, a bachelor's degree in criminal justice, and a master's degree in business administration.
And about how long did it take you to get those degrees?
Long time, approximately 10 years. I was a police officer while I was also going to graduate school.
And where were you a police officer at?
University of Texas at Tyler.
And to be a police officer with UT Tyler, did you have to be a certified police officer?
Yes, I went through the UT police system in Austin, Texas.
Can you tell me a little bit about that system?
It's a 6-month training, typical police academy where you're learning policies and procedures, state penal codes, arrest techniques, driving techniques, shooting, hand-to-hand techniques, various generalized law enforcement.
And about how long were you a police officer?
4 years.
And is it at that point after your degrees and your experience as a police officer that you applied to be with the ATF?
It took me 4 years to be hired. So while I did an internship with ATF when I was going to UT Tyler on my undergraduate degree. Knew that was my goal. Became a police officer to gather the experience. The hiring process was approximately 4 years.
Can you describe a little bit about that process?
Process of being hired?
Yes, sir.
It's very stringent. Typically, ATF has 2,500 federal agents throughout the United States. It's always been about that size. Our attrition is usually people that retire. It's approximately 100 agents a year. They open up the vacancy announcement, which is the generalized open application process. Typically, 5,000 to 10,000 people apply. They hire about 100 a year. So it's very, very stringent.
And once they hire you, can you tell me a little bit about that process?
Yes. So they sent me to Tulsa, Oklahoma. I got the duty agent phone call that said I was being hired. I went to Tulsa, Oklahoma, worked there for approximately 6 months till I was assigned an academy date. ATF attends a training academy in Glencoe, Georgia. It's also where, at the time, Border Patrol, U.S. Marshals, Customs, Secret Service, a lot of your federal agencies have combined training at this one facility in Glencoe, Georgia.
And so would Glencoe be kind of the equivalent of like Quantico for FBI?
Yes.
And can you tell me a little bit about your experience at Glencoe?
Sure. The entire training process there was approximately 6 months. Half of that was a generalized investigator training for those that basically didn't have law enforcement prior to. It taught you the laws and procedures and techniques of investigation, typically, because we are criminal investigators. And then the second half was more specific towards what we deal with as ATF agents: alcohol, tobacco, firearms, explosives, commercial arson, stuff more specialized towards what ATF agents do in general.
And so you mentioned some of your college education. Do you have any furthering education specific to while you've been on the job?
Yes, I'm also considered a firearms interstate nexus expert. What that means is I'm an expert and have been declared expert in numerous courts throughout the country of identification of firearms, the markings, where they're made, when they're made. I've toured numerous manufacturing facilities throughout the United States. I also go back and teach various blocks of that at our training academy.
And Your Honor, may I approach the witness?
Me.
And Agent Petrie, I'm going to show you what's enlarged and admitted as State's Exhibit 6. Can you take a look at that item?
Yes,
Can you describe what that item is?
this is a weapon made from a shotgun. It can be classified in two different manners. Weapon made from, because lawfully to possess firearms like this, they have to be an overall length of 26 inches and or the barrel has to be at least 18 inches long because it's a shotgun. And it's obvious that this one has been shortened on both the buttstock and the barrel.
And would you classify, so that appears to be a modified shotgun?
Yes, it originated its life as a shotgun that people would fire from the shoulder, typically for hunting of birds or things of that nature.
So in your training and experience, does that appear to be a prohibited weapon?
Yes,
And is that due to the length?
yes, these are considered concealable. Therefore, they're prohibited because they can be hidden under trench coats. The laws were originated with these weapons back in the early 30s when mobsters would carry them in Tommy guns underneath their trench coats because they're considered weapons of violence and they're readily concealable.
And Agent Petrie, can you tell me, does that shotgun appear to be readily operable right now?
It meets the definition of a firearm. I haven't actually tested it to see if it functions, but it was intended to be a weapon and it is capable of being readily converted to fire if it won't fire in this form.
And if I told you that the shotgun did not have a firing pin, could you tell me the process that it would take to
If that's the case, it's a pretty simple procedure to drop a firing pin in. This type of shotgun right here was manufactured by a J. Stevens company in the early 1900s to the 50s. They sold these types when they were in original form in like Sears and Roebuck's catalogs back in the day. There's probably hundreds of thousands, if not millions, of these very similar type shotguns that could use interchangeable parts.
And Agent Petrie, I want to kind of turn your attention to your when you became involved in this investigation. Do you recall December 4th of 2020?
Yes.
And did you have a chance to interview Mr. Young on that date?
Yes.
And Your Honor, may I approach again?
Yes, sir, you may.
Thanks. I'm going to show you what's been admitted as State's Exhibit number 8. Do you recognize that document, sir?
I do.
What is it?
This is a U.S. Department of Justice Advice of Rights and Waiver, commonly a Miranda waiver that is either read by somebody that you're interviewing. Typically, they're in custody. And I often read it to them, ask the person I'm interviewing that's in custody that has the right to an attorney if they want to waive that privilege to continue with the interview.
And is that the process you followed on December 4th of 2020?
Yes.
And did Mr. Young indicate that he understood his rights?
Yes.
And did he indicate that he wished to waive his rights and speak with you?
Yes.
And Your Honor, may I approach again? Thank you. And do you know whether Mr. Young was recorded?
Yes, it was.
Have you had an opportunity to review that recording?
Yes.
And the recording that's on that thumb drive, does it appear to be an accurate representation of the conversation?
I don't know what's on this thumb drive. This appears to be a way typical interview recording would be turned into the prosecutor's office. It's labeled with the case number, things of that nature, but without seeing what's on the thumb drive, I honestly don't know.
And Your Honor, at this point, the state would request to give Agent Petrie a chance to view the thumb drive to make sure that it is in fact the interview that he conducted.
What's the video?
The entire video is about 15 minutes, Your Honor.
All right, we're just going to stand in recess for 20 minutes to allow the witness to take the content on State's Exhibit 9. You are reminded that you've not heard all of the evidence in this case, not received the court's instructions on jury charge, and you've not received closing arguments, so you're not going to discuss this case with one another or anyone else, okay? So you're not required to stay in the jury room, go outside, take a break, welcome to do so. It's 20 till 3, so let's make sure that we're back in the jury room no later than 3 p.m. and make sure. Okay. All rise. Well,
It's not, all right, it's to comment on it.
Court's in recess. Pick up there. Go ahead, Mr. Hartwell. 98 stated. The second record reflects that the attorneys for the state, attorney for the defendant, and the jury is present. I believe that before the recess, there was a question to Agent Petrie regarding State's Exhibit 9. Just refresh the recollection of the jury. If we'll go ahead and pick up there, go ahead, Mr. Hartwell.
Thank you, Your Honor. And Agent Petrie, have you had an opportunity to view the video that's on State's Exhibit 9?
Yes,
And does that video appear to have some muted portions?
yes.
What is your understanding of those muted portions?
Parts of my conversation with Mr. Young involved things not relevant to this particular criminal investigation.
And other than those portions, is it a true and accurate copy?
Yes,
Your Honor, State offers State's Exhibit 9 with agreed redactions.
Any objection?
No objection, Your Honor, we've reviewed it.
Okay, then State's Exhibit 9 is admitted.
And Your Honor, permission to publish to the jury.
Granted.
And Your Honor, the alternate would.
Yes, sir. If you want to move out, you can, or if you just want to turn your chair and slide it back, if that's fine. Just whatever is most convenient for you. Yes. And if you could probably roll that cabinet back too, Mr. Hartwell, if you want to. There's still room. Stevens, can you see it from there?
Yes, sir.
Excellent.
You see it okay?
All right, folks, you're going to have to bear with this. They're about to play an audio recording or video recording. We can't see it, and with the echo in the courtroom, you can't understand it very well. But listen to the questions. They'll play a portion of the video, and then they'll ask this guy more questions about that video. So you'll be able to ascertain what the video is about and what he's asking about. It's going to pertain to, once again, the ownership of the firearm. And I hope my audio is now working. I had a snafu here on inputs, but I think I'm back running. Now, once again, you're listening to a video that was made on the scene at the day of the arrest. The audio quality is just not good in the courtroom as far as picking it up on the mics. So you'll have to kind of bear with that. But if I edit it out, you'll miss his answers. He's going to be asked a series of questions about this video audio as it progresses.
Are you ready for the CRI? Let me read this, you know, during that, I've got to read the right, good right, when they stop. Anything you say, you can record, you have the right to talk to a lawyer before asking any questions, you have a lawyer with during questions. You cannot afford a lawyer, from getting a lawyer, question.
You can hear them reading the Miranda rights on the audio that they're listening to in the courtroom.
If the waiver that you have read these rights by me, you understand them, this time we will answer questions about lawyer presence. No problem, you're correct, it may, no pressure force, anytime you get you. But I got back down by the. You know, the house that my mom's house. Yeah, it's my understanding is it can't be yours, right? No, I don't say that. I don't even know my own stuff. You know what I'm saying? I'm not saying yours, I mean, you know, that's what you say. I mean, I'm saying, when they're in, they need a place down too. I mean, my mom has to. What place you talking about in Dallas?
Yeah, and then another audio is difficult to hear. Let me help you out. This is the defendant speaking on a recorded device on the day that he was arrested, where they found the shotgun. He's explaining that this is not his house, but it's his mother's house, is the conversation that they're having now.
Where did you get locked up at? Okay, yeah. Oh, have you ever had a fire? I know somebody that looked at it. It's not what you're fine. But no, my cousin is very close that, you know. He was pretty good. That's fine. But,
Now they've asked him about how do you fire the shotgun, and he's saying, "I've never seen it fired. I don't know." Is basically what he said with most of that.
I know my girl, and I said that my front seat really wasn't my girlfriend, but you know that. So that I gave him about that, and then I did it home. Whenever they woke me up, and they, yeah, I don't know, but I mean, but the first I felt like it was Tyler's birthday, felt like it was like, they were actually good. Where they got top line, I know I'm not talking about it. I don't know that I don't know if that was something, so I think so there's nothing on the weekend. 26, 26, I put my hand front of my vehicle, that's part of my rifle. Yeah, but part of the thing is, my hand front did not be noticed. So the 22 rifle comes from the same place. Yeah, it is. You know, 5 years. Yeah, but you tell me that my mom.
And now he's talking about a rifle that was also found on the property, but he wasn't charged in this case with anything to do with that rifle. We did see them presented into evidence, but he wasn't charged with any part of that.
I don't know if you know them very well, but I don't look at them.
And while the audio is bad, I want to make another public service announcement. You never want to be a defendant and listen to yourself talking on a audio tape when the witness is not saying anything really about you. You're testifying. They're letting you testify against yourself, and they warn you anything you say can and will be used against you in a court of law. Don't be that guy.
Why did you get rid of it? I didn't know myself. I'm not perfect.
Now, another interesting portion of this was that last part where he says, "Why didn't you get rid of it?" What the defendant's saying is, "It's not my shotgun. I found it. It was in a car. I'm not sure if it was his car. Someone left it there. He takes it out and puts it into the freezer because he didn't want to have anything to do with it. Doesn't take it inside the house that he's living. Puts it in the freezer that's on the ground outside where they're living." So that's what the defendant's saying about this, and you'll see this pop up again in the defense's case.
Again, he said it looked like it was when it first got to his time, but you know what I'm saying? And it looked like somebody like he tried to play it up, or something. I don't know. I know that it does. I know for sure that it does not have fire in it. I know it does not.
And now they're talking about the firing pin in the shotgun. In Texas, it's very important that the firearm be operational. You could take I could take a machine gun from the military as a war trophy, lead the barrel, weld the action so that it can't be used, and it would be as the defense attorney said in this one, a relic, but it would be considered a curio, art piece, something you could hang on the wall, not a functional firearm. So the fact that this doesn't have a firing pin in it is a key part of this case. And they're asking him about whether he knows how to change a firing pin out, and he's saying, I don't know anything about it. He's saying he didn't know it didn't even have a firing pin. He said that lacks that much knowledge about that particular weapon.
And Agent Petrie, I just have a couple of follow-up questions. Was there anything that stood out to you about Mr. Young's discussion about firing the 22 rifle?
Yeah, my knowledge of the investigation, the 22 rifles in close proximity to the sawed-off shotgun.
And what would that the proximity and firing the 22? What would that indicate to you?
The knowledge that the firearms are there, knew that one worked and one didn't, which meant must have tried, or he's told me that somebody else did, but.
And there was some discussion about a firing pin, and you had mentioned that it doesn't matter according to the law. Does not having a firing pin, does that make a weapon not a firearm?
No, it just says it has to be readily converted or is intended to be fired by the means of an explosion. A firearm itself is a weapon, whether it's fired or not. It can be pointed at somebody and have the same intention. But if it's created to be a firearm, then it's a firearm.
And then your discussion about the fingerprints on the shotgun seemed Mr. Young was kind of equivocating there. What does that tell you in your experience as an agent?
That's a typical question I ask because a lot of people watch CSI, think that we get fingerprints off of everything, which is not accurate at all, especially when they're dealing a weapon like this. But what it does is it gives a measure of truthfulness. And when I saw him start to stammer and sputter, which is a common deceptive technique, I knew that he was probably worried about that question.
And then when you mentioned not looking to charge Mr. Young's mom, can you go into that a little bit and that exchange?
Correct. Throughout that interview, Mr. Young was trying to what I considered minimize his criminal involvement with this. He knew I was questioning him about it. So ways of doing that are to minimize what I knew or what I had, and then also try to place the blame on others. I could tell throughout the interview that although he acknowledged he knew it was there and in its presence, he was trying to say that his mother went and got it after he initially told me that Mr. Waddell called him. He said that Mr. Waddell, that his mother went and retrieved them and then brought them back to the house, which I informed him that is a violation of federal law because that's a prohibited weapon. And I wasn't looking to get his mother in trouble. The charge, when I used the word charge, meant get your mother in trouble. I just wanted the truth. I could tell that he was trying to deflect.
And then last question, are you familiar with, to your knowledge and experience, is there a definition for an antique gun?
Yes.
And would this firearm meet that definition?
No. Antique firearms are like muzzle loading firearms, black powder. They use an antique ignition source, or if they're manufactured prior to 1898. I'm familiar with these firearms. They were manufactured well after the 1900s, and it doesn't use an antique ignition system and doesn't take black powder. So it's what we consider a modern firearm.
Okay. Your Honor, state passes the witness.
Mr. Stevens, your witness.
Thank you, Your Honor. Special Agent Petrie, I'm Bill Stevens. I'm going to ask some questions. If I don't make sense, please just stop me.
Yes, sir.
All right. Now, was Mr. Young pretty much cooperative throughout that entire interview?
Yes.
And he did start off at first, correct me if I'm wrong, but didn't he start off at first telling you that his mom is the one that put the shotgun and also a TV in her trailer?
Well, yes, he changed his story a couple of times. He tried to tell me that it wasn't his trailer, but then he clearly says on the video that my house, my girlfriend must have moved him out of my house and they were underneath the TV. So I was never clear on the relation to when they got there, how they got there, or what the TV had anything to do with.
But he did initially say that his mother went and put him in there, correct?
Yes.
Initially. Okay.
Yes.
And then I believe his story might have changed after you, I don't want to say threatened him with his mom, but after you made the comment about, you're not going to throw your mom under the bus, are you? This is a federal offense. And that's when he then changed his story. Am I correct on that?
Correct. I was calling out his falsehoods to let him know that by him pointing his finger at somebody else and trying to place the blame, he could actually get them in trouble.
I know fingerprints were not taken from the shotgun. However, could they have been taken from the shotgun?
From that shotgun there?
Yes.
It could have been submitted, but they wouldn't have got anything off of it because of the rust and the wear. There's based on my training experience, there's nowhere on there that latent prints would be able to hold.
Okay. And do you have any way through your examination to determine when that shotgun was last fired?
No, sir.
So it might not have been fired for 30 years for all we know. Is that correct?
Possible.
Now, I just want to make sure the jury understands something. You were out there investigating this burglary initially, is that correct?
I never went to the scene that day.
Okay, but I mean, wasn't the feds investigating the theft of the gold coins?
Yes, I was assisting the Smith County Sheriff's Office with that.
Right, sir. And my client was not involved or not charged with anything involving the gold coins, correct?
I don't know that,
Okay.
to be honest.
You don't know if he was or was not.
Correct.
Okay. He was cooperative with you, was he not? When
Yes.
you were asking him about the gold coins.
Yes, sir.
Did his interview help you in any way locate the people that was responsible for stealing the gold coins?
Yes.
Pass the witness, Ron.
Mr. Harwell, your witness.
Thank you, Your Honor. Just real quick follow-up, Agent Petrie, mentioned earlier that without a firing pin, it's still a firearm. So kind of a follow-up question to that, without a firing pin, would it still be a prohibited weapon?
Correct.
State pass the witness, Your Honor.
Mr. Steven,
No further questions.
any objection to Agent Petrie being finally excused?
Your Honor, state would ask that he be subject to recall, but no objection to just being within a phone call.
Okay, Agent Petrie, so you're still able to discuss your testimony with anyone else, allow them to discuss their testimony with you, not required to stay in the courthouse, but subject to recall by both the state. Yeah, what's your statement? All right, does the state wish to call any additional witnesses?
No, Your Honor, state rests.
State rests its evidence at this time.
Yes, sir.
Mr. Stevens, would you like your opening statement at this time?
No opening statement, Your Honor.
So that's waived. Does the defense wish to call any witnesses?
Yes, Your Honor.
Who would you like to call?
Sheila Prater, Your Honor.
Sheila Crater?
Prater.
Prater.
Prater, yes, sir.
E-R-A.
Prater.
Thank you.
I believe that's how it's spelled, Judge.
This is going to be the defendant's mother they're calling to the stand, the one that was throw you under the bus comment.
You raise your right hand. So the place you swear that the testimony that the court today will be the truth, the whole truth, and nothing but the truth. So thank you, ma'am. Once you're still up, because you in there, okay, that chair does move around, so you can adjust it. Just make sure I see that you have your cell phone. If you wouldn't mind just like giving he does have that. Let him have that so make sure it's really quiet.
But, okay.
Adjust your chair so we can get closer to the microphone.
Okay.
Later during your testimony, to speak up loudly and clearly so everyone can hear what you have to say. My court reporter here is taking down a record of everyone's saying, okay? So
Okay.
it's very important that you allow your attorneys to finish the questions before you give an answer, so we're not talking at the same time, which would be very difficult for her. If during your testimony, either attorney objects, they stand up, so Your Honor, I object. To stop testifying, the court will rule on that, or let you know whether it is or not, okay? And then finally, if you hear an emergency vehicle or a loud truck, the attorney's going to stop asking questions. If that happens to your testimony, want you to stop so that time can pass, so that we can all hear what you have to say, okay? Mr. Stevens,
Judge, may we approach?
you may.
There's going to be some discussion about whether her testimony would incriminate her. And that's what they're doing a little sidebar with right now.
Ladies and gentlemen, there's a legal issue that must take up outside your presence. So I'm going to put you in recess. I'm not sure how soon. So it's about 20 till 4. I'm going to say let's do the recess for 50 minutes. We're back in the jury room no later than 3:55. Checking on you. Remember to follow the instructions I've given you so far. Don't discuss this case with each other or anything. Okay, let's all rise for the jury.
All right, folks, I left this portion in. This is technically, the jury won't hear what's about to happen, but I think it's important to something that we talk about a lot on my platform, which are what your rights are and what law enforcement is there to do.
A suggestion that are you going to be seated? All right, let the record reflect that the jury has been excused, that this hearing is conducted outside their presence. Court has done so on the suggestion that some of the questions may implicate the Fifth Amendment rights of the witness, Ms. Prater. And is your name Sheila Prater?
Yes,
Is it Sheila?
no, LIA,
Lia?
yes,
Is it Prater?
yes.
Thank you, ma'am. And so I think at this time, what I would do is just allow you, Mr. Stevens, to just summarize what issues that you believe are going to be the subject of Ms. Prater's testimony that could implicate her Fifth Amendment rights.
Yes, Your Honor. I'll be asking her, we've heard testimony already that it's stated that my client put the shotgun in the travel trailer and that my client lives there. Her testimony is going to be that she is the one that put the shotgun there and that my client doesn't live there, that she did. With that being said, it's a prohibited weapon. And if she testifies that she put it there, then that could open herself up to liability. So that's my concern, Your Honor. And I did visit with Ms. Prater and I did explain those, concerns with her. So that's a perimeter of kind of what I'm talking about, Judge.
Any response from the state?
So, Your Honor, I guess in light of that, of those facts, I don't know that it's necessarily relevant to the case at bar in light of the fact that it's a possession of the weapon as to who moved what or where, but rather the fact that he was aware and he's testified to the fact that he had them there.
Right. This is not a question about him. This is a question about her. Do you have a response to his questioning of her and whether or not she should have counsel? I just want to.
Well, she absolutely should if she's going to be admitting that she in fact was handling an illegal weapon.
So what's the statute of limitations for possessing a prohibited weapon?
Your Honor, I believe under the state, it would be 3 years. I don't know what it would be federally though.
We need to find that out. I think you have an ATF agent who's called.
Is he still hanging around? We can find out real quick.
Perhaps you should step out and give him a call. I don't know what the statute of limitation is for.
I don't either.
For a federal allegation of prohibited weapon. If it's, when did the Van Zandt County Sheriff's Office take possession of this weapon? On November 25th, 2020?
Yes, sir.
So here we are almost 4 years later. So if the statute of limitations has run, then there might not be any criminal.
No, that's proven. It's run.
Now, that begs the question, doesn't mean that law enforcement couldn't make an allegation. It just means a prosecution can't be had. It doesn't mean that a law enforcement officer couldn't be standing outside the door waiting to arrest her. Just means that a prosecution wouldn't be successful because it wouldn't be timely. Right. You all agree?
Yes, sir.
Yes. Okay. So what I would like to do is I'm going to stand in recess for a few minutes. I would ask the state to contact Agent Petrie and see if you can get a quick answer for the court and a reference to the CFR that, or whatever, or USC, whatever the reference is, and get the court a quick answer on that, so I don't have to go research that. And
Okay. What we're seeing here is proper. This woman is going to get on the stand, and if she says that she was in possession of a short-barreled shotgun, she could expose herself to criminal prosecution both on a state and a federal level. So we don't ask people to testify against themselves. You have a constitutional right not to do that. Your Fifth Amendment. And I think the judge is being proper with this.
Number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury. Due to the nature of the direct examination and potential cross-examination of this witness, Miss Sheila Prater, the court finds that her Fifth Amendment rights against self-incrimination could become an issue. And so the court has found Miss Prater to be indigent, and the court is going to appoint the Honorable Richard Schmidt to advise Ms. Prater both prior to and during her testimony regarding her Fifth Amendment rights. The court tomorrow, after she has received the advice of counsel, will also admonish her as to her Fifth Amendment right. But unfortunately, Mr. Schmidt would not be available today on such late notice. It is 4 p.m. So I think it's best to recess for the day. So I'm going to tell the jury that we're going to come back in the morning at 9 a.m. Ms. Prater, I'm going to order you to come back at 8:30 in the morning. 8:30 in the morning, and there you will meet with Mr. Richard Schmidt, attorney.
Okay.
And he's going to talk to you about your testimony and any implications it could have regarding any potential arrest or prosecution that could stem from that. Okay. And so I don't want you to say anything at this time, but you'll meet with him in the morning and he will advise you and counsel you. And he'll be here during your testimony and can be here if you have any legal questions. Okay. And so I believe you've given the contact information to my coordinator, Ms. Tabraham. Is that correct?
Yes.
Okay. And so I'm going to order you to come back at 8:30, and then we'll begin promptly at 9 a.m. Any issues on that matter from counsel?
No, sir.
Any other?
No, sir.
Any other issues we need to take up?
No, sir, not that I'm aware of.
So the defense has indicated that they believe that Ms. Prater will be the last defense witness. Is that correct?
That is correct, Your Honor.
Okay. All right. So Ms. Prater, I'm going to go ahead and I'm going to leave you where you're at.
Okay.
The jury in, and I'm just going to let the jury know that there's an issue that we're going to deal with and that we're going to resume tomorrow. And that's what we're going to do.
Okay.
All right. Let's all rise for the jury.
Folks, that's this portion for this week. We saw the ATF testify. We saw the mother of the defendant attempt to testify. Who's got a mic open? Isn't that you, Chris? Gotcha. But I've got me in studio, folks. We got Tim Williamson off of X Freed Merc 65 on the X platform. I've got my co-host B Wayne and Grizzly Greg in here with us. Let's take a moment and see what they think. Tim, I think I had audio problems, and I assumed you had audio problems earlier. Can you speak?
Can you hear me?
Boy, I got you now.
Okay, brother.
So I know I know my co-host has been following the case, and you've been following it as well. What's your temperature with it this far? If you were sitting on the jury and asked to decide now, where would you be?
Ooh. First, let me say I thought that was an excellent witness. The gun expert.
You thought the ATF was the best witness the state's had this far, huh?
Yes, I think so. I'm still not real comfortable with how the Smith County. We go to, was it Van Zandt County?
That's correct.
Apparently, the illegal firearm in question, was it either in view or was discovered? There was seems like to me some conversation about
what had happened. What had happened was,
thank you.
that there's a pretty large value dollar amount burglary that happened in Smith County. Smith County and Van Zandt County in Texas are two adjacent counties. They're next door to each other. Smith County is where Tyler, Texas is, one of the larger municipalities there. So they're running down. They had a burglary that involved a lot of gold coins, a lot of high dollar value items that were stolen out of a house in Smith County. Smith County gets word that their suspects could absolutely be in Van Zandt County and got an address probably talking from Van Zandt County from what it sounds like. We did hear that a little bit of that in the testimony from the Van Zandt County detective, that the subjects there in this location were known, that they'd been handled before. So they may have told them, hey, these guys may be good for something like that. Smith County goes out. They recognize a vehicle that was named as a suspect vehicle in the burglary parked on this piece of property. When we say it's a residence, this is not like in a neighborhood. We got a driveway. Most likely, it's probably 3 or 4 acres of land. It's got a trailer house and a driveway up to it. Typically, it will have a longer driveway. So they see this vehicle there and they make contact. Inside the vehicle, they see enough items that they believe to be connected to the burglary, that they've got enough from going to the residence and seeing on view these items there. And they write themselves a search warrant, notify Van Zandt County. They're running paper in their county. Van Zandt County shows up. During this search, they discover inside of a freezer a sawed-off shotgun. The one that we're talking about today was inside of a freezer. Remember, on the property, you've got a double-wide trailer and you've got a travel pull-behind trailer like a camper parked behind the residence. And I suspect that they hadn't said this, but the way they talk about them being parked, the only reasonable reason that you would do that is that you're sharing this single septic tank between the two domiciles, the trailer and the double wide. But they discovered the shotgun during running a evidentiary search warrant for items that were taken in a burglary. So that's how it lined up. That's how Smith County gets there. Smith County was the first detective or investigator interviewed. He is not the arresting agency, and his agency has no cases, and they made that very clear, has no cases against this defendant sitting in the courtroom that we're watching. Only Van Zandt County, which would be the second detective or investigator that testified, the one that actually held the shotgun up and held the rifle. That's the arresting officer, so to speak. Did that help clear it up any or make it more difficult to understand?
No, that clears it up, and that was my overall recollection of what occurred. That the let me say the Smith County detectives came across the illegal firearm, correct?
No, I believe it was the Van Zandt County.
Okay, I'm sorry. Okay.
By the time
Anyway.
the search warrant had been signed and got there, both agencies are on site.
Okay. All right. Yeah.
And let me tell you how I know that. If I'm in another county and I need a search warrant signed, I've got to have a judge in that county sign it in that jurisdiction. And my first call is going to be to whatever agency there. Hey, you got a number to a judge. So I'm pretty sure that's how that went.
Okay. All right. Well, that clears a lot up for me. As far as
Well, let me ask you this: what instead of just you don't have to give me a full assessment. We're just kind of talking about it now. We'll have the jury in a week and a half or 2 weeks. What about it's hanging you up? What about it you don't like? That doesn't sit well with you. And if you don't have an answer, brother, it's okay. I'm going to Bruce Wayne and Grizz on it.
Oh, okay. If I don't have a problem with it, then I mean, as far as all the right people were consulted and there was a warrant. The gun was discovered. Assuming you don't have a separate warrant just for the gun, correct?
No, as long as it's found in good faith and in a location that items you are searching for could be secreted. Give you an example. If I'm looking for a pickup truck, anything I find in someone's living room on a search warrant, it's probably not going to fly because you couldn't hide a pickup truck in someone's living room.
Got you. Yeah, I'm good. I'm good then.
Okay, Bruce Wayne, what do you think?
Yeah, I'm finding it real interesting. I don't have a problem with anything so far. I did find that interesting. The ATF saying that it is still a firearm even if it's not functioning is good. Good clarification. Good definition that was given. I did find it interesting. Them bringing up the statute of limitations at the end. Was that regarding the search warrant? right?
Now, the statute of limitations was brought up. The lady that got up to testify, the defendant's mother, could be asked questions that she would incriminate herself. She said that, hey, that was my shotgun. I carried it there. I put it in the freezer. Then she could expose herself to criminal prosecution by testifying truthfully. So you have the right not to do that on the Fifth Amendment. What the judge was doing was trying to clear the way to see, does he have a Fifth Amendment issue or not? He had a little hearing to decide that. And that's why he asked about the statute of limitations. Statute of limitations had gone for the state of Texas, but the feds could have picked up the case, and therefore he decided to go. Well, actually, I think he went that way because even if the statute of limitation had run out, wouldn't prevent anybody, if they wanted to, law enforcement wise, to arrest her when she got off the stand by her own statements. Even though she may beat the prosecution, she wouldn't beat the ride. And the judge decided that that was too much peril for her to be in.
Okay, gotcha. And I'm kind of confused now. I thought there was the man was on trial. Is the woman on trial, or are they both trying to
The
figure out
woman is
who's-
the man's mother. She's the owner of the property where the gun was found.
And he was saying it was her house, but then he took blame for the gun because he didn't want to get her in trouble, right? Or that's the way that he was being told.
Right. That's the defense theory.
Okay. Yeah. No, I'm real excited for next week. Honestly, it's getting a lot of twists and turns. It's getting interesting.
Well, folks, join us next week, same time. Hopefully my production will be a bit better. I've had some real world work, that's been taking my time and my energy, but I think we'll be okay for next week. We'll have the rest of the defense case, and then we'll seat our jury. I'll have to announce it. I'm not sure how much of the defense we have left. If we've got a full episode, then we'll seat the jury the following. And we'll start discussing and deliberating as jurors before we hear what the real jury had to say. But before we go, scan and join our Patreon group. You get early releases on case videos for our Friday night show. And there'll be some more perks coming up. I hadn't figured out exactly what it is. Well, here's a big perk. Our first jury for this show here, Night Court, will be from our Patreon support tier members. And that's where we will select our jury from. Actually, right now, everyone who in our support tier group that wants to be on the jury will be able to be on the jury. So join the group. It's got some perks there. It's good stuff. Last thing before we go, we're going to have an after party here on the grand jury. We can discuss this a little bit more and any more details on the case. Give us about 20 minutes and we'll kick it up on X. Anybody that wants a personal invite to that, shoot me a DM and I'll get it to you. Thank you guys for you guys in studio spending the evening with us, and all you folks listening and watching. We do appreciate you giving us the time. Thanks, guys.
Intentionally or knowingly possess a short barrel firearm, to wit, an Eastern Arms 16-gauge shotgun, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Hartwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty.
Can you please describe what he is wearing and where he is seated?
He's seated at the table there, and he's wearing a light blue shirt.
And you mentioned earlier that you got a search warrant put together. Were you able to execute that search warrant?
Yes, we were.
And what kind of property were y'all actually looking for?
We were looking for gold, coins, and other precious metals, firearms, and items that were specifically taken from that specific residence.